A new immigration law has just been signed in the United States, and if you're already a green card holder, or you're dreaming of becoming one, this changes everything. Some of you are about to see your wait times shrink and new doors open. Others may face new rules, new risks, and responsibilities you've never had to think about before. Stay with me right until the end, because what I'm about to explain could completely reshape your immigration journey, your travel plans, and even your long-term future in America. Welcome back to Immigration Newsroom, your trusted source for clear, step-by-step explanations of the latest immigration and visa developments. In today's video, we're breaking down a major immigration law that has just been passed in the US. This isn't a rumor or a social media headline. This is real legislation with real consequences for millions of people. Whether you already hold a green card, you're in the middle of a petition, or you're just starting to plan your American dream, this new law will touch almost every part of the system in some way. In the next several minutes, I'll walk you through exactly what changed, who benefits the most, who needs to be extra careful, and the concrete steps you should take next. I'll also share common mistakes people are already starting to make in response to this law, and how you can avoid them. So if you can, grab a notebook, put your phone on silent, and stay focused, because this is dense but extremely important information. As always, here at Immigration Newsroom, remember that this video is for general information and education only. I'm not your personal attorney, and this is not individualized legal advice. Immigration law is complex, and your situation is unique, so always speak with a qualified immigration lawyer and verify everything with official government sources like USCIS.gov and your local U.S. embassy or consulate. Let's begin with one of the biggest changes. The law creates a streamlined processing system for employment-based green card applicants. For years, we've watched highly skilled workers, especially from countries like India and China, sit in backlogs so long that their children age out and their careers are put on hold. That wait has felt endless and unfair. This law is designed to attack that problem directly. Under the new rules, USCIS is now required by law to process most employment-based green card applications within 180 days. That's 6 months from the date your case is properly filed and complete. There will still be exceptions for security checks and fraud investigations, but the general rule is no more endless waiting that stretches into many years just for a final decision. To make this possible, the law allocates new funding specifically for immigration processing. USCIS will be hiring more officers, expanding service centers, and investing heavily in digital case systems. Many of you know the frustration of mailing a stack of papers and then waiting months just to see the first update. The long-term goal of this law is to move more of that process online, with clearer status updates and fewer lost documents. What does that mean for you in real life? If you're on an H-1B, L-1, O-1, or another employment-based status, and your employer has already started your green card process, or is about to, this change could literally cut years off your expected wait. Instead of living in immigration limbo, renewing work visas over and over, you may be able to plan your life with a much clearer timeline. The law also introduces premium processing for certain green card categories themselves, not just for non-immigrant petitions. For an additional fee, eligible applicants will be able to request a decision within roughly 30 to 45 days once USCIS accepts the case for premium handling. This won't apply to every category on day one. The agency will roll it out in phases, and there will be conditions to qualify. But the principle is clear. If you need a quicker decision and you're willing to pay extra, there will be a legal path to get that speed. We do have to stay realistic. Even with new laws, implementation takes time. USCIS has to write regulations, train staff, update forms, and set up technology before everything works exactly as promised. So don't expect every case filed tomorrow to be magically decided in 6 months. But the direction is unmistakable. The government is finally acknowledging that the backlog crisis is unsustainable and is committing in law to reduce those waits. If you're watching this from India, China, the Philippines, Mexico, or any country where the visa bulletin has been painfully backlogged for years, take a deep breath. Your patience and persistence are finally being recognized in the text of U.S. law. Now we need to shift to an area where you must be very careful, especially if you already hold a green card. Not every change in this law is positive or lenient. Some parts are much stricter than before. The law introduces tighter guidelines around permanent residence and physical presence in the United States. In the past, many green card holders assumed that as long as they entered the U.S. once a year or kept trips under 6 months, they were safe. In practice, that was never fully accurate, but many people acted as if it were. Under the new law, if you spend more than 6 months outside the United States in a single trip without a valid re-entry permit, your case may now be automatically flagged for review. That doesn't mean you automatically lose your status, but it does mean you could face much tougher questioning at the border and during future renewals or naturalization. Officers will be instructed to look at whether you truly live in the U.S. or you're just visiting occasionally while your real life is somewhere else. More seriously, if you spend more than one continuous year outside the United States without the proper permission, you now face a significantly higher risk of being treated as if you abandoned your permanent residence. In that situation, you could be required to start over with a returning resident visa or a whole new immigrant petition. Unless you can prove strong, ongoing ties to the U.S., things like owning or renting a home here, keeping your immediate family here, maintaining full-time U.S. employment, or other evidence that your real home is America. In addition, the law adds a yearly online confirmation of residence. Every green card holder will be required to file a short electronic form once a year confirming their current U.S. address and affirming that they still consider the United States their primary residence. The form itself is supposed to be simple. It might take 5 minutes, but missing it repeatedly can trigger flags in the system. If that sounds stressful, here's the key reassurance. If you actually live in the United States, work here, pay taxes here, and only travel abroad for ordinary vacations or short visits, you are exactly the kind of resident the system is designed to protect. This part of the law is aimed at people who obtained a green card, but essentially moved back to another country while trying to keep U.S. status as a backup plan. So what should you do? If you know you'll need to spend extended time outside the U.S., for example, caring for a sick parent, completing a work assignment, or pursuing studies, talk to an immigration lawyer before you leave. You may be able to apply for a re-entry permit, document your situation, and protect your status legally instead of hoping for the best at the airport. Now let's move into one of the most exciting and hopeful parts of this new law, especially for those working in hospitals, clinics, and long-term care. The United States is experiencing a severe shortage of healthcare professionals, nurses, doctors, physician assistants, therapists, home health aides, and many more. This law responds to that crisis by creating a fast-track pathway to green cards for qualified healthcare workers. If you're already working in the U.S. in a healthcare role on a valid temporary visa, you may now be eligible to apply for a green card without going through the usual lengthy labor certification process. In many cases, your years of service during staffing shortages and public health emergencies will count as proof that your skills are needed. On top of that, the law sets aside an additional 25,000 immigrant visas per year, specifically for healthcare workers and their immediate families. These visas are separate from the usual employment-based caps, meaning they shouldn't directly cut into other categories. This is intended to reduce competition and bottlenecks for qualified nurses, doctors, therapists, lab technicians, pharmacists, and certain long-term care workers. To avoid abuse, there are also new worker protection rules. Employers will not be allowed to exploit your immigration status by underpaying you or threatening to fire you if you consider changing jobs. Wages must meet or exceed prevailing standards, and contracts must be transparent. The idea is to attract and retain skilled healthcare professionals without trapping them in unfair situations. If you're watching from the Philippines as a nurse, from Pakistan as a physician, from Nigeria as a medical technologist, or from any country where healthcare professionals dream of working in the U.S., this law could dramatically change your trajectory. Start gathering your licenses, employment records, recommendation letters, and proof of experience. Talk to a lawyer about whether you qualify for this fast track and what steps you need to take to convert your current status into permanent residence. Next, we need to talk about the public charge rule, because this is an area where many people are confused and understandably worried. The new law reinstates and strengthens public charge review for certain green card applications and even some renewals. In simple terms, immigration officials are now required to look more closely at whether someone is likely to become primarily dependent on certain government benefits. Let me be clear. This does not mean that using any public benefit automatically disqualifies you. Life happens. People lose jobs, get sick, and need help temporarily. Short-term or emergency assistance doesn't automatically make you a public charge. But the law tells USCIS to weigh your overall financial situation more heavily when deciding on your application. They may look at your employment history and current job, your income level compared to the poverty guidelines, your education and skills, your savings and assets, and your history of using certain long-term cash benefits or housing programs. If you've received extensive public benefits for more than 12 months in the last 3 years, your case may face additional scrutiny. That doesn't guarantee a denial, but you may be asked to provide more documents or a stronger affidavit of support from a sponsor. So what can you do to prepare? If you plan to apply for a green card or adjust your status in the near future, focus now on building financial stability. Even a part-time job that shows consistent income can help. Keep clean, organized records of your pay stubs, tax returns, and bank statements. If you needed public assistance in the past, keep any documents that show the temporary nature of that help and your current recovery. The goal of this part of the law, according to its supporters, is to prioritize applicants who are likely to be self-sufficient. Whether you agree or disagree with that policy, you need to understand the rules so you can position your case as strongly as possible. Now let's talk about a group that has been living in uncertainty for far too long. Dreamers. People who were brought to the U.S. as children, grew up here, and often know no other home. For years, many dreamers have relied on DACA, a temporary program that provides protection from deportation and work authorization, but no direct path to permanent status. Every 2 years, they've had to renew, not knowing whether the program would survive legal and political battles. This new law finally creates a permanent legal pathway to green cards for dreamers who meet certain requirements. To qualify, applicants will generally need to show continuous residence in the U.S. for a specified number of years, arrival in the U.S. at a young age, no serious criminal record, and completion of a certain level of education, vocational training, or military service. Those who qualify will be able to apply directly for permanent residence rather than relying on temporary, renewable protections. The law also allows many dreamers, once they obtain green cards, to sponsor certain family members, spouses, minor children, and in some cases parents, opening a path to reunification that simply didn't exist before. Processing for these applications is supposed to be prioritized, with a stated goal of finishing most cases within about 12 months. There are also provisions for fee assistance or payment plans for applicants who can demonstrate financial hardship, recognizing that many dreamers have faced economic barriers because of their previous immigration status. If you are a dreamer watching this, you deserve to understand this law in detail and to get solid legal guidance as soon as possible. Start gathering school records, employment history, tax returns, DACA approval notices, and any other documents that show your life and contributions in the United States. This may be the chance you have waited for your entire adult life. Now let's turn to entrepreneurs, innovators, and investors, people whose ideas and businesses create jobs and drive the economy forward. The new law introduces a startup visa pathway that allows certain foreign founders to apply for green cards based on their business success and job creation, rather than traditional employer sponsorship. To qualify, you may need to show that you founded or co-founded a qualifying startup in the U.S., that the company has raised a minimum level of funding from verified investors, for example, at least $250,000 from recognized venture capital firms, angel investors, or government grants, and that your business has created a specified number of full-time jobs for U.S. workers, often 5 or more, though the exact number will depend on the final regulations. If you meet these thresholds, you could bypass some of the traditional hurdles and apply directly for a green card as an entrepreneur, rather than trying to fit your situation into an employment or family category that doesn't match your reality. At the same time, the law modifies the EB-5 investor program. It allows lower minimum investment amounts in certain rural or high unemployment areas, for example, decreasing the threshold from $800,000 to around $500,000 in designated regions. The goal is to encourage investment where it's needed most, while still demanding real, job-creating projects. To reduce fraud, the law requires stricter monitoring of regional centers, more transparent reporting, and heavier penalties for projects that misuse funds. That protects both investors and the credibility of the program itself. If you're a founder or investor considering these options, do not rush into any deal based on a YouTube video alone. Study the regulations carefully, work with experienced lawyers and financial advisors, and be wary of anyone promising guaranteed results. But understand this: for the first time, U.S. law is sending a very clear message. If you build real businesses and create real jobs, there is now a more direct immigration path for you. Now we come to a change that affects every single green card holder, regardless of how you obtained your status. Starting 6 months from the effective date of the law, all green card holders will be required to go through a biometric renewal process every 10 years. This will be tied to your regular card renewal schedule. When your card is coming up for renewal, you'll receive a notice to attend an appointment at a USCIS application support center. There, officers will collect updated fingerprints, a new photograph, and, in many cases, an iris scan. The actual appointment is usually quick, often less than 30 minutes, but attendance will be mandatory unless you have a serious, documented reason to reschedule. At the same time, the government will begin issuing a digital version of your green card in addition to the physical card. This secure digital credential will be accessible through an official government app or online portal. You may be able to use it for things like employment verification, certain travel processes, and identity confirmation with government agencies. The purpose, according to lawmakers, is to fight fraud and identity theft, and to ensure that records remain current as people's appearances and biometric data change over time. It's also part of a broader push to modernize the immigration system and reduce dependence on easily damaged plastic cards. For you, the key takeaway is simple. Do not ignore renewal notices. Mark your calendar, update your mailing address with USCIS anytime you move, and make sure you attend your biometric appointment when scheduled. You worked incredibly hard to obtain permanent residence. Don't risk complications because of a missed email or unopened letter. Before we wrap up, let's go over some of the most common mistakes people are likely to make in response to these changes and how you can avoid them. Some people will delay taking action because they're overwhelmed or waiting for everything to be perfect. With a law this complex, there will always be new clarifications and tweaks, but that doesn't mean you should sit still. If a new fast-track path opens for your category, whether you're a healthcare worker, a dreamer, a startup founder, or a longtime H-1B, start gathering documents and talking to professionals now. Others will rely on rumors and social media instead of official information. You might hear that someone's cousin's friend got a green card in 2 weeks, or that nobody needs to worry about public charge anymore. Don't build your life on secondhand stories. Every case is different. Always base decisions on written law, official guidance, and direct advice from a qualified attorney. Some green card holders will continue treating their status like a long-term visitor visa, spending most of their time abroad and only flying in occasionally. Under the new stricter residence rules, that approach is riskier than ever. If your real life is in another country and the U.S. is just one of many stops, you may not be acting as a true permanent resident in the eyes of the law. Others will panic about public benefits and stop using programs they genuinely need for medical emergencies or short-term crises. Remember, the law looks at your overall financial picture, not one visit to the doctor or 1 month of help during a disaster. The goal is not to push families into homelessness or untreated illness. Use what you truly need, but work on building long-term independence. And many will skip professional help because they think lawyers are too expensive. Sometimes, a one-time consultation can save you years of delay or prevent a life-changing mistake. If cost is an issue, look for nonprofit legal clinics, bar association referral programs, or organizations that provide low-cost or sliding-scale immigration help. So after all of this information, what should your next steps be? If you're an employment-based applicant, talk to your employer and attorney about how the new 180-day rule and premium processing options may affect your case. Ask whether it makes sense to file sooner, upgrade, or adjust your strategy. If you're a current green card holder, review your travel history and future plans. If you've been spending long periods outside the U.S., consider whether you need a re-entry permit or other documentation to protect your status. Set reminders for yearly residence confirmations and future biometric renewals. If you're a healthcare worker, start collecting proof of your qualifications, licenses, and work history. This law was written with you in mind. The U.S. is sending a clear signal that your skills and sacrifices are valued. If you are a dreamer, this may be the first time the law fully recognizes that the U.S. is your home. Don't rush blindly, but don't ignore this moment either. Educate yourself, speak with trusted legal advocates, and begin preparing a strong, well-documented application when the process officially opens. If you're an entrepreneur or investor, dig deeper into the startup and EB-5 provisions. These are powerful options, but they come with serious financial and legal responsibilities. Do your homework thoroughly. And for everyone, keep watching Immigration Newsroom. We will continue to track every update, every regulation, every court challenge, and every clarification that comes out of this new law. When forms change, when procedures open, and when real people start getting approvals under these categories, we'll bring those stories and explanations to you. To summarize in plain language, a major new immigration law has just been passed in the United States. It promises faster processing for many employment-based green cards, stricter rules for long absences by permanent residents, a powerful fast track for healthcare workers, a stronger focus on financial self-sufficiency, a long-awaited permanent path for dreamers, new opportunities for entrepreneurs and investors, and modernized biometric renewals and digital green cards for everyone. Some of you will find new hope and opportunity in these changes. Others will need to adjust habits, travel patterns, and financial planning to stay fully compliant. Through it all, remember, you are not alone. Millions of people around the world are navigating these same questions right now. If you found this breakdown helpful, make sure you subscribe to Immigration Newsroom. Turn on the notification bell so you don't miss urgent updates, and share this video with friends or family whose immigration plans could be affected by this new law. Tell me in the comments, where are you watching from? Are you already a green card holder, or are you still on your way? What part of this new law worries you the most, or gives you the most hope? I read as many comments as I can, and your questions help shape future videos. Thank you for spending this time with me here at Immigration Newsroom. Stay informed, stay organized, and stay hopeful. Laws can be complicated, but knowledge is power, and together, we'll keep working to make your immigration journey as clear and successful as possible.